Good evening to all. I am Akash Tiwari, Associate at JMVD Legal. Welcome you all on behalf of JMVD Legal in this webinar session on protecting trade secrets in India. For a smooth flow of session, I request all the participants to please mute their mic for better listening. All the queries and doubts will be taken at the end of session. Still, you can raise the question in the chat box mentioned in the app. Before starting the session, I would like to introduce firm JMVD Legal is in the industry for more than 25 years as an corporate tax, IPR, and business advisory law firm. We provide end-to-end legal solutions, having excellent and dedicated team of insolvency professionals, attorney, chartered accountants, company secretaries, and engineers. Our major specialties are in insolvency and bankruptcy, income tax, indirect tax, corporate laws, banking laws, alternate disputes resolutions, labor and general laws, service laws, patent laws, trademark law, copyright laws, design laws, geographical indicators laws, securities laws, competition law, real estate laws, proprietary laws, cyber laws, FEMA, corporate restructuring, and environmental laws. Further highlighting towards today's session speaker, Advocate Amit Dubey is a partner of JMVD Legal and head of IPR division, working as an advocate at MP High Court and a patent agent and trademark agent appointed by the Controller General of Patent and Government of India. Also, an intellectual property facilitator appointed by Government of India for Startup India program. He completed his LLB honors from IIT Kharagpur and BTech in Petroleum Engineering from UPS Dehradun. Now, I would like to request Mr. Amit Dubey to start this session.
Good evening to all of you. So, am I audible to everyone? Akash? So, today's session it is on trade secrets in India and analyzing its legal position on trade secrets in India. Trade secrets, as we understand, we can say it's a most traditional form of intellectual property. Because if we go in erstwhile scenario or in our historical times, any of the intellectual property started with as a trade secret, and recently we have seen the new forms like patents, copyrights, and trademark. But trade secret is from inevitable times, and any of the IPR it starts as a trade secret, and later on it assumes the different scenarios of other types of IPR. So we should move on. So just you can identify these are some of the trade secrets like KFC, Coca-Cola, Google algorithm, Listerine Coolment, Ruafza. So major advantage they are getting from trade secret is that trade secrets we don't have any specific time period for protection. In case of patents, it is for only expires after 20 years. But for example, in trade secrets, that till the time it is undisclosed or you are able to keep it confidential, it enjoys the trade secret. You enjoy the trade secret rights, and you are able to derive profits out of your secrets. So coming to the definition part, trade secret is a formula, process, device, or other business information. So most important part, it should be as kept confidential to maintain an advantage over the competitors. So first important thing is it should be confidential, and second thing, it should have an advantage. It should give you an advantage over your competitors. And it has in recent times it has increased its width, because nowadays lot of information we have in e-format, and for example information include because it includes formula, pattern, compilation, program, device, method, techniques, and which derives independent economic value. So it means that it also includes your client list. For example, you are a firm, professional firm, so you might be having your client list, and you might be having a list of people who is the key contact in your client company, whom to contact for such and such in such scenarios, and for such any particular work whom to be contacted. So this our client list and all becomes some confidential information. And so they all becomes the trade secrets. So a trade secret refers to any information which is not disclosed to general public and which owner attempts to keep confidential. So most important part is that owner should attempt it to keep confidential, and it should not be disclosed to public. So these are some of the famous trade secrets. For example, Coca-Cola, because the Coca-Cola what formula or composition they are using, it's totally trade secrets. This WD-40 formula, KFC, Big Mac special sauce. In case of KFC, it is said that they have incorporated two companies, and both the companies are manufacturing two different types of mixtures based on some document, and later on this mixture is been mixed by a altogether different machine which runs on a software, and that software is being coded as per their trade secret, and that secret they have preserved in some vault at unknown place. So these are some general types of trade secrets, like financial information, your So these are some of the types of trade secrets, like financial information, technical and scientific information, your commercial information, even negative information is covered under trade secret. For example, you might be having knowledge what not to do if you are doing any business. So you should have having a list of data which is not to do, or you should abstain yourself from committing such acts. So that is also is your confidential information and shouldn't be leaked to your competitors. So these are some of the examples of trade secrets, like marketing strategies, your manufacturing techniques, computer algorithms, your formula, for example, of some sports drink, survey method used by professional, or pollsters, how they are giving opinion polls and how they are conducting the same. Food recipes is the widest form of trade secret. We generally see various chains of restaurants, various food centers and all. Any new invention for which a patent application has not yet been filed. So till the time you have not filed your patent application, it enjoys the category of trade secrets. So as we saw that the most important feature is to keep it as a confidential. So what is required to maintain a trade secret, we will see now. Here a very good cartoon is there which states that Leonardo da Vinci never allowed anyone to watch him at work. So you can see that how important is trade secrets, and it's present till from historical times. So trade secrets are neglected sibling and yet may represent larger single contribution to intangible assets. And in today's time, companies enjoy maximum of their assets under intangible class. Even nowadays they have started capitalizing the same whatever expenses they have incurred for their intangible assets. So even this trade secret expenses can also be capitalized. So recently we have seen the COVID-19 situation where maximum of mainly the service provider companies have started the work from home feature, and even the employees who are mainly into service providing and doing any office works and all, they are allowed to do work from home. So it has also increased the scenario of trade secrets, like where several employers are providing employees with remote access options work from home. So you are allowing your employees sitting at home and accessing your confidential data. So in response to the effect of COVID-19, enabling them to work outside of the traditional corporate environment, the safety of their homes. So remote access relies on the exchange and transfer of information and data, typically over the internet. So it doesn't mean that only employees can risk your confidential data. Even third parties can also hack or do any unauthorized access, and they can harm your confidential data. So with more employees relying on technology to work remotely and access proprietary information, they are increasing attempts to exploit sensitive data. So companies should work with legal counsel to craft remote working policies that address the importance of protecting their confidential data being used through online mode by employees sitting at their home, then companies should limit printing and physical copies of confidential information. We generally see that in office, we ask our employees not to print confidential data because it becomes very easier to for unauthorized access. But same is very much tougher to enforce the same printing guidelines for work from home. So there should be some policy for the same and restrict remote access to any such printed information within their home, just as they would in the office. Company should also prevent employees from storing proprietary information on their personal devices or transmitting work-related information over public networks by equipping employees with work-issued devices and secure network access. For example, our employer is using his own cloud or server, and employee is being seen using Google or Gmail or Google Drive of on his personal account. So that can also compromise your confidential data. So mainly companies should require that most confidential documents are password protected, and when it's most sensitive documents are transferred electronically, that like for email or anyway, even nowadays WhatsApp and all. So it should have a continued password and sent separately and part from the document. If you're setting up, like even you're sending some PDF, so it should be password protected, and an employee should be able to open only to use of that password, or even OTPs can also be used, like OTP is generated in their mobiles. If you're setting up remote virtual desktop, ensure only key employees have complete access to the trade secret info. No need to give all of the confidential data access to each and every employee. Ask them to only allow them only to access such information for which they are required, which is mandated for them. So now we see that what generally practices are followed. So we might have listened a lot of about non-disclosure agreements, like employees generally enter into NDAs with person who knows the business secret, so that he will be under contractual obligation not to reveal them. So here we are not making any statutory right in our favor. We are entering into a contract, and by way of that we are making a new right or enforceable right with the help of contract. So it can be entered between employer and employee, or even with a new business entity, your franchisee, or the persons, your distributors to whom you are with whom you are working. So now come to the legal scenario. We have some definition, the TRIPS agreement, so which lays down following basic criteria for any information, and there it's not dealt as trade secret, it is dealt as undisclosed information. So as per TRIPS, the data must not be readily accessible or known by those individuals who deal such sort of information generally. So it shouldn't be readily accessible. That means it should be highly confidential. Then second, the information must have a commercial value as secret, because if any information which don't have any commercial value, it doesn't qualify as a trade secret. The lawful owners of the same must have taken reasonable steps to ensure its secrecy. That amounts to that means the owner should have taken reasonable steps to ensure its secrecy. For example, we can say as Coca-Cola formula for its aerated drinks, KFC recipe for its delicious fried chicken are considered to be trade secrets which have been preserved for many decades. So now in India, even India is obligated to protect undisclosed information as provided under TRIPS. However, member states have a sui generis mechanism. That means you can have your own law, your own way of protecting it. So Indian courts have generally preferred to apply common law principles for granting injunctions in absence of any specific act or regulation made by the government to protect trade secrets. So that means we don't have any statutory protection, but but courts are very proactive, and they are providing common law remedies in such circumstances. Now I will deal with some of the legislations which can be used to protect trade secrets, and I will call it as a basket of legislations. For example, we can see as the Indian Contract Act, Information Technology Act, Indian Penal Code, Copyright Act, SEBI prohibition of insider trading regulations, and National Innovation Bill, which has not been converted into act. So we will deal now all of them. So what remedies you have? Like for example, civil remedy. So in civil remedy, you can approach the court with a civil suit for an injunction against the unauthorized or illegal user. But here, for getting interim orders, you should have three things: that is prima facie case in favor of an injunction. Second, balance of convenience is in favor of granting the injunction, and there is a risk and irreparable loss has to be seen, which comes under Order 39 orders. So these three has to be shown for getting interim injunctions. So same can be protected through Indian Contract Act by entering into NDAs, but such NDAs shouldn't be in violative of Section 27 of the Indian Contract Act, which provides that there shouldn't be any restraint to trade. Or, for example, the employee is working with an employer, and at the time of his termination, he has been asked that you shouldn't be allowed to work in the same field for about 5 years. So it should be seen on fact to fact basis that it's not violative of Section 27. You're not restrict. For example, a person who is skilled in the same area, employee, so we can't restrict him that he won't be working in this particular area for next 5 years. So that will very much prejudice to his own business in his own service, whatever service he takes afterwards. So now coming to IT Act, Section 72, it provides that where a person may be punished under this section if he is found to have secure access to any electronic record, book, register, information, document, or other material without the consent of the person concerned, and such first person discloses such information further. So there are three parts. First, he should have found to have a secured access. Second, it is without the consent of the owner, and third is that the such first person discloses such information further. That means the person who has accessed it, he has disclosed further such information. So now coming to the criminal remedy, trade secret violation can also be said as theft under criminal law, and same can be punishable. But for making as a theft, it should have a physical form, like for example, client list, formula, or blueprints, and must be proven to have actually been stolen. Now coming to the section 408 and 420 of Indian Penal Code, for criminal breach of trust, and 420 for cheating. So only in situation where an agreement express or implied exists, then only we can go for criminal breach of trust. So prima facie for criminal breach of trust, it's required that there should be an express or implied trust exists. Then only this remedy is there for us. Now, criminal breach of trust, section 408, as we discussed, it says that whoever being a clerk or servant or employed as a clerk or servant and being in any manner entrusted in such capacity with property or with any dominion over property commits criminal breach of trust in respect of that property shall be punishable with imprisonment and so on and so. So, main important part is that he should be employed, and then he is being in any manner entrusted with such capacity with the property that he has some access with the same, and he has committed then criminal breach of trust. Now coming to the cheating section 415, whoever by deceiving any person fraudulently or dishonestly induces the person so deceived to deliver any property to any person, or to consent that any person shall retain any property, or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if he were not so deceived, and which act or omission causes or is likely to cause damage or harm to that person's body, mind, reputation, or property is said to be cheat. So which can be further then extended to section 420, and a remedy will lie for cheating under section 420. Now, now it will be seen that how Copyright Act comes into play. Sometimes trade secrets can also be extended as a copyright form, because for example, if it's your client list, you have some list or your information data which is being in a stored form, so it can be taken as a literary work, and it should be original, and a labor work has been done for its preparation, so it can fall under Copyright Act, and copyright violation provisions can be used. There's a good thing is that with the help of copyright we have broader remedies, and we have direct provisions under Copyright Act. There's a simple difference between the both. Like in trade secret, it's for hidden information and process. Copyright should is for published work. So that means for trade secret, even to qualify as copyright, it should be published. Not to mean that it's published to general public. It should be in some recorded form with you to qualify at least as a literary work. Registration is none for trade secrets. For copyright, it's voluntarily. Then for disclosure in trade secrets, none. If you disclose, it won't be a trade secret, but copyright it's required. For trade secret, criteria is reasonable effort to maintain secrecy. That is the important factor. For copyright, it's original contribution. Rights for trade secrets, you can have damages, claim damages for theft, but in case of copyright you have to limit reproduction. Duration is potentially forever in case of trade secrets until it gets disclosed. In case of copyrights, it's 60 years from the age of the death of the author. Then for strength in trade secrets, it's weak, and copyright is average, we can say. Patent is the highest having this strength. Now coming to this SEBI prohibition of insider trading regulation, it states that this act renders the use and disclosure of confidential information by any insider subject to prosecution under SEBI. So the confidential data which is with the board of directors or any key KMPs, and if they disclose it and it's violative of SEBI regulations, so it amounts to insider trading. And it can also say that in particular to that part, trade secret is being protected with the help of SEBI regulations. Innovation bill, it was a National Innovation Act 2008 was proposed, but it is not being passed by the parliament. And but it was published, and it was sought to codify and consolidate the law of confidentiality and aid in protecting confidential information, trade secrets, and information. We in 2015 we saw a very important Commercial Courts Act, and it has been very fruitful for commercial litigations. Even intellectual property is being covered under this law, because we saw that generally for IP infringements we have to approach civil courts, and civil courts were already burdened, and there was very lot of issues regarding to timely disposal of matters. And so we got this Commercial Courts Act 2015, which established a special commercial court in district courts, and generally it is being taken by some additional district judge. He presides this court, and appeals from commercial courts directly lie before the divisional bench of the High Court. That's the beauty of this act. So, but the thing is that we will come to the definition of commercial disputes. So whatever is a commercial disputes under this act, you have a right to approach. Plaintiff can go for such disputes to commercial courts directly. But coming to section 2C, which provides intellectual property rights relating to registered and unregistered trademarks, copyright, patent, design, domain names, geographical indications, and semiconductor integrated circuits. So you can see that nowhere it mentions about trade secret, confidential data, undisclosed information. So trade secret is out of the ambit of the Commercial Courts Act. So in my view, trade secret should also be considered to be part of commercial disputes. These are some of the notable provisions of commercial courts. which are given him added advantages, like if no return statement filed by defendant within 120 days from date of having been served with the summons, the right to file a WS stands abdicated. Even post 90 days, he has to file a separate IEA for the filing of WS, and same is allowed generally with costs. Evidence is to be recorded on day-to-day basis. Judgment is to be pronounced within 90 days of the conclusion of arguments. The Act also prohibits review or revision of an interlocutory order passed by a commercial court. This is the last one. Then aggrieved party can challenge an interlocutor only in appeal to the final degree made in the case, but subject to Order 43. Order 43 orders can be appealed. And Section 8 of the Arbitration Conciliation Act, any application filed under Section 8 is also an order passed for such application is also appealable order. Now we'll see some of the judicial pronouncements for trade secrets. For this was the case of John Richard Brady versus Chemical Process Equipments. Here it was a case where there was no contract or NDA was signed between, but the court held that independent of an underlying contract or in absence of one, he who has received information in confidence is not allowed to take unfair advantage of it. So this lays down that undue enrichment at the expense or detriment of another goes against the equity and fairness, which need not be dependent on contractual obligations. So it can be seen that even we don't have any NDA, in such cases injunction has been passed based on grounds of equity and fairness, and to see that there is no unfair advantage. This is the very famous case of American Express Bank versus Priya Puri. It was a case of 2000. First order came in 2006. It was a case of Delhi High Court. So the fact of the case was that defendant was the head. Priya Puri was the defendant of head of the wealth management for the plaintiff in Northern India. When she submitted her resignation to plaintiff and was serving a 30-day notice period thereunder, it was lately found by the plaintiff that she had disclosed confidential information to persons which was not in connection with the business of the company. So within notice period, she acted in such manner and used confidential information and trade secrets for her own benefit, violated the American Express customer privacy policy, revealed customer list to the competitor. So in that case, court went into was of the view that trade secrets do not cover the knowledge attained through daily operations, and in totality of circumstances, the plaintiff bank failed to make out a strong prima facie case in the favor. So it was held that this whatever an employee is gaining out of his whatever knowledge from his daily operations, you can't make same into the trade secret. So it's a very thin line is there between trade secrets and knowledge gained under employment. And even it was held that any negative covenant through contract form is restraining employee from engaging or undertaking employment for 12 months after leaving services is in violation of section 27. So injunction was declined in this case. This was another case of Diljit Titus versus Seema Ahluwalia. It was related to a law firm where it was court held this trade secrets like client list and all to be a copyrighted item. So whether the client list and other confidential data has the copyright, this was the issue before the court. And the court held that data was covered as a literary work under the Copyright Act, and the owner of any work done in course of an employment is the employer and not the author himself. So plaintiff has made the investment and he has the sole proprietor of the firm, and all the major decision in this case was taken by the plaintiff, and defendant when left the firm there was no division of property. So generally it says that when you have a defendant is a partner of the firm and he leaves the firm, so there will be a separate case, and here he was not the partner, so it was held that he has no right over the confidential information, and it was held to be the copyright infringement. So these are some of the documents that can be signed for protecting trade secrets, like non-competition agreement and employee confidentiality agreement, non-disclosure agreements, authorized disclosure by the board of directors of the company, termination of agreement and statement, invention assignment agreement and its applicability, and injunction relief agreements. And these are some of the practical ways to protect trade secret, like employer should label the information to be confidential. Whatever documents he is issuing, whatever it's being circulated, it should have with red color, it should be highlighted as being confidential. There should be restricted access to databases, servers, and computer program, and only the person who has are required to access are allowed to access such information, and that too for a limited duration. And there should be a random change of passwords, and random even shifts should be there. Ensure that access to server is password protected, and that a suitable note is displayed on computer screens when accessing sensitive areas. Sign non-disclosure agreements with any third parties, like for example small business, MSME, startups. So they can't do a lot of things, but they can at least have a proper NDA signed and non-disclosure agreement signed with their, for example in case of startups, they are entering into with some developer for the development of their app or software, so they should enter with the NDAs. Even for example for developers also, they might be having a lot of interns with them, or trainees, or staffs, or associates. So he should also enter in some NDAs with them to protect the rights of their clients. So, and they should use a combination of technical and legal solution to protect their databases. So it's all of the things should be a sync between technical and legal solutions. So these are some of the advantages of trade secret. So protection is for unlimited duration. There is no a time limit. Your protection is theoretically worldwide. No public disclosure or registration with government agency. No application required. No registration cost, and just effectively immediately. So only whole of the cost lies before your your protection regime. So how much you can able to protect that, that only defines your trade secret. So thank you very much. It was very nice talking with all of you. So you can post any questions. Akash, what questions we have?
Yes, sir. There is one question uh, from Durgesh Chaudhary. Kindly confirm what is the cost involved in doing trade secrets and where we have to file for it.
So, sir, as we had discussed, there is no registration mechanism or any for trade secret. Trade secret all depends on us and what type of documentation we are doing, and it's a combination of technical and legal solution, and only depends on case to case basis. So it all cost involved is only this enforcement mechanism for this technical and legal solutions, and it has to be done by us only. There is no government agency for trade secrets. Any another question, Akash?
No, sir. If anyone has any question, you can ask now.
Hello, Amit.
Yes.
Hi. Thank you for this lovely webinar. I think that has clarified a lot of questions. So one, live, real case scenario that people in consulting industry faces, or the people who are working in the KPO industry, basically for the knowledge and processing and outsourcing thing, that an employee who is bound to companies regulations under confidentiality clause, etc. So my question to you is, number one is, do the company have that kind of power in hand to basically prosecute that person who actually in case they find that he has actually breached that code of conduct in terms of confidentiality? And number two, a lot of the companies have such kind of practices, not directly, but it is understandable that if they are poaching some employee of the other company, definitely, I mean, if let's say a biscuit manufacturer poaches an employee of biscuit manufacturer B, or consulting company A poaches the employee of a consulting company B. So definitely they have this in place, that some kind of trait or some kinds of methodology, some kind of data this person already possess. So what is the kind of barrier, or what is the kind of protectionism that they can keep in place to avoid such kind of jeopardizing of business?
In my view, there are two sort of things. One is the like one information you have received because of your skills and due to your knowledge on the area, and you have acquired during. But and there is another form of confidential data which is exclusively of your employer and his because of his labor, and you have been accessed to the same in the course of your employment. So they're two separate things, and it should be separated. And even in case of NDAs, same has to be categorically separated to help even the employee for his future jobs. And if any breach happens to only confidential data pertaining to employer, then only I think action lies. And same was the case of even this Priyapuri case. So only there should be some segregation between the two.
Okay, thank you. That answers.
Sir, here is one more question.
Yes.
From Mukesh Shukla. Do we need separate legislation for the protection of trade secrets in India?
Yeah, that attempt has been already made with the help of innovation bill, and I feel that a separate legislation is required for the protection of trade secrets in India, as we have DTSA in United States. So there should be proper law in India defining what is trade secret, how it should be protected, what's the mechanism for confidentiality, and even covering the issue what. We noticed that how employers and employer relation is being affected due to this confidential data. So there should be proper definition and criteria to understand what comes under confidential data. So there's a proper legislation is required.
One more question from Preeti. Can trade secret be held as collateral with banks?
That is very I can't have a very proper answer to it, because like banks won't take it as a collateral, because you have to for keeping it as collateral, it means that you will be disclosing the same information with the bank, and even post for and prior to that it will be required that same what is the valuation has to be done. So it require all this valuation exercise and collateral exercise can lead to the disclosure of the same. So if all protected regime happens and there's a proper protection between you and bank of your confidential data, so then we can think on it.
So there is one more question from Ashita Khandelwal. If there is no registration, then how can I get a legal remedy from the use of my trade secrets?
As already stated, like generally courts have been approached in civil remedies, like you have your NDAs, so you can go for enforcement of agreement clause. You might be having some liquidated damages, or even for unliquidated damages. In such cases, you can go for enforcement of NDAs. And if no NDA is there, then also you can file a suit for damages under common law for tort being done to you. Even you have some remedies under criminal law as discussed, like under IPC, under Information Technology Act. So it totally depends on case to case basis. And but as discussed, that same should be included under Commercial Courts Act, proper enforcement and proper usage of judicial mechanism.
Sir, there is one question from Vikas Tiwari. What thing is actually protected under trade secret? As without law, each court will have their separate discretion in elaborating the scope, and the people might take trade secret protection towards something that is not protected under patent?
No, trade secret and patent is altogether different thing. We have a specific, because trade secret is much wider than patent. Patent has very narrower definition, and which is being is covered as being as an inventive step for and having non-obvious such criteria has to be fulfilled for becoming the patent. And trade secret is very much wider. Trade secret, only important thing is that it should be confidential, and your owner has done a significant for mechanisms for protecting it, and if this and it's being used against your competitor, and it shouldn't be disclosed. So such criteria, if it's there, any information, anything can be covered as a trade secret.
So one more question from Akash Tiwari, that how can the valuation of trade secrets be done? Is it similar to patent or any other method?
Trade secrets can be valued like other intellectual properties. For example, in the cost-based mechanism or income-based mechanism, or what is marketability of the same. But same thing will arise as we discussed in that the question relating to collateral with banks. So proper valuation and all mechanisms has to be seen that it's being your trade secret is protected and it's not disclosed to third parties. Even in a recent valuation mechanism, we have only three class. One is financial assets, one is land and building, and one is plant and machinery. So we don't find any place for intellectual property there. But and there is no proper valuation rules also for IPR. So IPR is totally open subject, and it's being valued on case to case basis only.
Amit, if I can interrupt here, I'm sorry.
Yes,
Do you have any transaction that has happened recently? You need not name the industry, I mean, the name of the firm or something, but if any, relative valuation or any, case or transaction that has happened, and you can understand from a percentage, you can, tell us a ballpark number on what exactly would likely be a trade secret. I mean, that would really help. If in case you having, came across one.
no, for example, you are asking about valuation?
Yes, please.
Valuation by a percentage or proportion?
Yeah, correct.
Yes. No, the thing is that recently I was involved in one of the case. So that company was having some, they was providing some of the instruments. So they were not having patent over the same, and they were only planning to file the application. But in between, but they plan to have a valuation of the same to show that they're for proper, because apart from that trade secret, they don't have any for any asset in their proper asset in their company. The same which happens with a lot of startups, because whatever assets they have, that is their trade secret, and apart from trade secret, they don't have any significant assets in case of startups. So in case of startups, if any valuation happens, a major part will be this trade secrets, and it can be valued on the basis that what result it makes, what revenue it is generating, what proportion, and if you want to trade that confidential data in market, what actual value you can realize from that confidential data, that will be an important part. It can be seen that once that confidential data will be traded to another person, you won't be in a position to use it. So that scenarios has to be seen, and that will be a major chunk of value.
Okay, so you mean to say that this could be benchmarked to some other similar type of industry functions?
No, that problem will be there, similar and comparable, but you won't be finding any comparable on the market or
Right.
any trade secret.
Okay, thank you.
Any other question, Akash?
Sir, here is one more question from Durgesh Chaudhary. I am in agrochemical company. So what is the best way between patent and trade secrets for agrochemical formulations?
In my view, if you are not hit by patentability under Section 3 of the Patents Act, so only remedy lying with you will be the trade secrets. And till when till that, and patent is having a limited period of 20 years. So it overall it will depend that whatever your formulation it is, you have life of the same. Like for example, various technologies are there which becomes irrelevant after 10 years or 15 years and need to be innovated, or further advancement has to be made. So if anything which is will be over by 20 years, so patent is appropriate and it's a very better protection, having proper statute and all. And if you find that this your formulation is having a very long term prospects, more than 20 years, so we can go for trade secrets.
Okay, sir, here is one more question. Is existence of NDA compulsory for enforcing any action against stealing of trade secrets?
No, NDA is an option. It's any, because like if you don't have NDA, you will left with only theft remedy under Indian Penal Code, and in theft you have to show that it's having some tangible form. So without NDA, it will become very tough for you to define what is, because once you enter into NDA, you are able to mark that what is your confidential data, how you will be enforcing it, what amounts to confidential data, what are the liabilities of both the parties. So NDA is very good form of protection, but it depends that how it's drafted, and proper drafting is the best way to protect.
Okay. Anyone has any question? I think all the questions are answered, so we can proceed to end this session. I would like to thank you, Advocate Amit Dubey, for such a wonderful session. I hope all the participants are now much aware about trade secrets. Again, I extend my gratitude to all the participants. Thank you.
Thank you.
Uh, for for PPT, you can drop a Gmail ID here. We can send an email.